multiple choice. I have the multiple choice practice final exam here because I have no internet, so I couldn't upload. I'm going to do some tomorrow when I go to the law office because their internet works, but mine for the whole week. Last Thursday started. When I left this class, I went home, there was no internet. Now I have 3 computers at home and all 3 of them are not working. This is the first time that I had problem with Verizon. Verizon has been very good. They sent me a new modem on Monday, which I appreciate it. I got the modem connected and still no changes. When I go to the browser, it just tells me connecting, you know, like the commercial shows and the circles on it, nothing happens. Nothing happens. So it looks like, and then of course when I call them, they look at the monitor just like I see some student looking at now and they say, oh my goodness, everything is connected from their sides, but they are numbers. They are pictures, you know what I'm saying? And I says, well, nothing is connected from this side. So would you get off your behind and come over here and find out what is it? There must be a switch or something that it's not coming into my house to connect with the computers. So I was so upset yesterday. I told them that if they don't have the connection on by this morning, I'm going to cancel the services with Verizon. So I'll find out tonight if I have email completely or they canceled already, or I don't know. I have no idea because I was out all day. But tomorrow I'm going to the law office and I'm going to upload the practice final multiple choice questions because I know some of you are not here today because you know, marriage or interview or whatever it is. Having a baby or whatever, you know what I'm saying? I know you have all kinds of things. And also I want you to know that that's why I printed out at the law firm and I brought it over today because I want to make sure you already have it. Now what I'm teaching today is international law. It's going to be a lot nicer because I have something on the multiple choice questions, but not as much as the other ones that you have to have it for the CPA. Some of those things I really, I think it's more, I don't know why they have it because I know they're going to change. And the other thing I want you to just being aware of your professional responsibility, and it goes back always to liability. And I want you to know the purpose that, or the kind of law that might hit you, and not so much go to PowerPoint because it's really being ethical. I really to this day, I really believe that no matter how many rules and regulations we have, because all this time, especially the second part, you had to deal with statutory law. There was nothing to do with the Constitution. And all those laws that we had to go over, like, you know, the Sherman Act, the security, that is for the good of society, not necessarily for you as a person, as an accountant or a lawyer or a doctor. Good. It's for all the banks, and it's all for the people. Remember, all those laws that are protecting the bank, it's also trying to protect you. But usually the bank gets a lot more protection because the banks have lobbying, and the banks are the ones that have 90 days to change the laws, because when I was a corporate attorney, that's what we used to do. But you, the depositor, or the person that is involved in stock or investing anything, you don't even know these laws are coming. You know, the laws are written, and then it takes 2 years before you are aware of it, and you never have a chance to say something about your side. Where the statute really, the people, the business people, the big business like banking, a stock market, corporation, they have 90 days to say something in those laws. But you and I have nothing to say. So I want you to know that the statutory law is really to protect big business, not you and I, little people. You know what I'm saying? However, when we do get hurt from them, we have the keys to go to court. So I guess it's better than nothing. You know, but you have to be very careful because one word in that statute might not cover you. That you don't think, oh, we have, you know, SOX, great. But you have to say, what's the purpose of SOX? Only for investors. And then there has to be what? Public. You have to be very careful on who is really protecting under this law. Not everybody is protected just because we hear that. You know, like the investor or a whistleblower then, because they'd say to you, oh my goodness, you're an employee of a bank, then you know what's going on, so we're going to encourage you to whistle. You know, this is something almost new in a way. But however, remember, the whistleblower has to do what? has to be an American citizen, has to be what? A public company, has to be, it's very interesting because not everybody can just say, oh, I know there's some corruption going in my company. It would be nice we could do that, but we don't because we don't have the laws for everything. It's like, I see like Band-Aid. It really goes back to you, the person, because so many times we have motions to have people pay for child support. We have motion to restrain people a certain distance so that they don't hurt and they still break it. So it's no matter how many times I win something, it still depends on the defendant to comply with the law. And in this country, they can go in Europe, they can even change state, and we cannot do anything about it. So it's really us, what's inside of us, how much we want to do it. So as much as I like to see all these laws, because at least we have a keys, but I also know that it's not easy. Plus it's expensive. Plus it's expensive. So when you're going to be an accountant, you're going to have your own business, and you're going to write the contract or a retainer if you want to do it. The best thing for you is looking into, instead of litigation, try to see if you can settle mediation or arbitration, because it's cheaper. Also ethics comes in, values comes in, culture comes in. There's a little bit of compromise there, and it's more of a win and win situation because both of you have to agree to the settlement. Where in a court of law, it's winning or losing. And boy, we don't like loser. We don't like loser. And next thing you know, the loser is going to want to appeal it to the appellate court, and the appellate court might reverse, and next thing you know, on and on, constantly with the boxing glove. And that's not the way to do business. Really, it's very too expensive, and it's especially if you're a solo practitioner or you have your own office. So we're going to go this like an outline because I want you to see all the different ways that you may be sued. The laws that is, in a way, protecting more the big business. Okay. The international law is what I enjoy because we are in a global economy, plus because I wasn't born in this country and I saw the difference of the laws. So I like to teach that, and I'm going to also use cases that I didn't see it in your textbook. I think I saw only one. I try not to use the same cases. So if you have any question, please stop me, because it's so important to know who are these people. You're going to do business maybe online. I mean, I just finished teaching a cybercrime over an NGOT, and it's amazing some of the stuff. Like somebody was on Facebook imitating another person, you know, like, and next thing you know, this person now committed a crime of identity theft. This is something that it's overwhelming. Sometimes we're kidding around in Facebook and we pretend, you know, like Tom Selleck, me, I'm always talking about him, and I'm pretending I'm Tom Selleck. You know, and maybe Tom Selleck would say, hey, Diana Walsh, who are you? You're what? You're using my identity, and I can be accused for identity theft, so I cannot kid around about Tom Selleck on Facebook. You know, these are the little things that we're taking as fun, and we enjoy each other and pretending we're somebody else, you know, for a while. But it's nowadays because of the internet, and you cannot take it back. You cannot take it back when you send that email or anything, and you're going to deal with that more than I do. Like I said to Howard, I'm so glad I'm on the way out, because I don't have to have a whole life like you have. You're going to do everything on the internet, pretty much, everything. Shopping, you name it, you know, everything. You're going to find your wife, you're going to have your kids through the internet. I mean, gosh, that's what I see anyhow. Okay, so I'm going to cover that, and then I'm going to give you the multiple choice, and I'm going to ask you then what to do for next week, because some of you cannot come because you're going for a second interview, and that's more important than anything else. Okay, let's see. Any questions so far? Any suggestions? Yes? No suggestion? Everything is okay. Good. I know you have a lot of stuff in your head. I know you're like brain dead. I know it because I remember going to law school and I couldn't believe it. And then when I took the bar exam, I did not know if it was in English or in Latin. So I know exactly what you're doing. But you know, somehow when you're going to start seeing something, first of all, pray. That's all I can tell you. Pray for wisdom, because you need that a lot. But when you see all those questions and when you see that, and it's going to be, let's put it this way. You are in control, not the multiple choice. Remember that. Not the you're in control. Be careful. If as soon as you get afraid or as soon as you get overwhelmed, that's when you make mistakes. That's what I found. As soon as I start to get a little bit nervous, I forget things. No, you are in control. You learned. You're going to have the book to go over the practice. I'm going to take 100 of the one I'm giving to you. You understand what's the purpose here. Make society better without harming it. When you're doing something with statutory, it's for the good of society. So when you're going to take the multiple choice, don't see yourself as an individual. You have to say, hey, is this good for society? And when you have a question and you see the A, B, C, and S question, you have to put that answer that goes with the question, thinking always it's not for my own good, it's this for make us a better society without harming it. So if you have the power or the authority from stopping from someone to get hurt little one, you may be liable. To the point now that we're making a person or profession like you or mine or doctor or anybody else responsible for the third person. That means when I have a contract with a person, I have to think like, well, maybe by me saying something to this person, a third party that is a friend of this person might have a lawsuit against me. Because you don't know what this person that you have a contract is going to advise someone else. This is a new thing, the third party. You know what I say? So be very careful. In a way, we're becoming more of a lonely society than ever. But just those are the most important things. Okay, let's go into international law. What's the principle of comity? I also have handout. This is so important because by you understanding these terms, you know why we have the problems we have with Syria, with Libya, with all these nations that we are getting involved. You know, and we are the United States, and we are such a small part of the world society. What is the act of state doctrine? And I gave you some problems that deals with that, because you're going to be dealing in a global economy, unless you want to be just, New Jersey. Under the Foreigner Sovereignty Immunities Act of 1976, you see, these are not that old, these laws. It's not 1876, it's not 1819. This is 1976. And that is something because most of the nation in the rest of the world, their government is immune from lawsuit. Here in the United States, we don't agree that because remember, we are the governors. Not the government is not the government. The government is under our service, if you want to call it, all the three branches. So what we are saying is we the people, we don't believe that the government is sovereignty and knows everything. That's not, even the person we elect, they don't know everything. However, we can sue them in this country. The only thing what we do is we limit the time. We're not going to give 2 years for tort. We're not going to give 6 years for contract. We're not going to give 4 years for the Uniform Commercial Code. You have 90 days, pretty much. These are the typical time that we do that. That's why I want you to be, and of course, the only time then, it has to be a commercial activity. And you're going to see the cases I give you when you're dealing with another government, which most of the time other governments do own their business, and they don't see it as a commercial activity, but we do see it as a commercial activity, and then we can have a litigation. Otherwise, if they say, no, it's not a commercial activity, and many times we have to go to court to show to the court, yes, it is a commercial, because as soon as you say to someone, this is wrong, oh yeah, what makes you think? You're king or something that you can do that? It comes natural. We just do things like that. That's all there is to it, no matter what we do it. In what circumstances would United States antitrust laws be applied extra? So what's the meaning of antitrust laws? Do you remember? Again, the purpose there. When companies get together and make a trust, and next thing you know, if you're not a member of that trust, you put together with the prices, and if you don't want to become a member, next thing you know, they charge the prices lower, and next thing you know, you lose the money until you're almost forced to do that. This is something that started many years ago, and nowadays they are more strict. And we don't want monopoly. We believe in competition. We believe in each one have equal opportunity to become successful or become big business or things like that. So, do United States law prohibit prohibiting employment discrimination apply in all circumstances to United States employees? You're going to see from the cases, no, it doesn't. This is why we have outsourcing. That's why we have outsourcing. And you're going to see that. Okay. Again, remember what is law? Including litigation or legislation or the Constitution or case law, common law. This is what we're talking about. Because the rest of the world, a lot of the rest of the world have civil code law, which is very similar to the administrative law. And what's the difference between the administrative law, which I call it for branch of government, from regular legislation? And the administrative law is very similar. The administrative law tells you what kind of letter to write, what kind of form, how many days. They even define what is an employer, for example, in the Civil Rights Act. They tell you any company that has more than 25 employees, they have to comply with the Civil Rights Act. You know, any company that has less than 25, that means they can discriminate all they want to. But then we have state laws. And the state laws, we have it also in New Jersey that says, you know, and these are the things that I want you to see how administrative, and then when you have something like discrimination under administrative law, which is very similar to the civil code in the rest of the world, you have to follow the procedures of the agency, the regulatory agency. You have to have that full, and you know, you go through some of the thing now to apply to Rutgers, the bureaucracy of the papers. And then you always find a person that is very much, no, the comma has to go here and not over there, and they make you do the paper all over again. And then you know there are some people that say, okay, I understand, your machine broke down, you're going to do it, I'll accept it. That, and you're dealing with people all the time. But administrative law is very similar to the civil code of the rest of the world. And that causes, but this is very important that you know. Whatever it is, whether it's administrative law, whether it's the Constitution in this country or legislation, both federal or state, the whole purpose that we have law in this country or in the rest of the world is to govern relationship among individual, between individual and their society. That's why other countries have laws too. You know, in a way it's controlling, and controlling people to behave in a certain way according to the culture. And of course, our prevailing culture is with the one that wrote the Constitution. We have a tendency to lean to a British, English, accent value and way of doing things. And of course, it's getting more and more difficult because we're not a homogeneous society. And under the Constitution, we're supposed to be treating everybody equal. But not everybody has the same values like when the Constitution was written. So how you can treat people equal when my value is different from yours? And the other day, we got an email that they want us to teach internet ethics. Anything to do with technology, you have to take internet ethics. Why? Because the internet is dealing with what? Different nations, and every nation has different values. So if we're going to go into the internet and we're going to have e-contracts and we're going to have e-situations and we're going to be communicating with each other on the internet, we're going to have internet ethics. There has to be some kind of universal behavior in the internet that is acceptable. And then, of course, also find out where are we going to argue when someone does breach that kind of ethics behavior, which I find very interesting. Because internet ethics, it's almost like when you're on the internet, you're a different person, I guess. And I guess you could be. Because, you know, with all the different software, we can do anything else. But this is so important that I want you to remember. So when you're taking your CPA exam or a multiple choice, especially anything to do with law, a little 21%, I think I heard is 15 to 21% of your final, of your CPA exam is legal. Just remember the purpose of the whole legal situation is to govern, to have some kind of behavior, some kind of conduct. And in the United States is to reflect the homogeneous society that made this country what it is, which is more what? The Anglo-Saxon value. Work hard. No extracurricular activity. All these things like that. This is why you see that. What is national law? What is national law? Do we have national law or we have international law here in the United States? National law is the federal law. National law is federal law. And then we have state laws. And then we have local ordinance because every town thinks that they are better than the other town. My town thinks it's better than Wayne. Wayne thinks it's better than, you know, Newark. I mean, you name it. There is a competition between towns all the time. Law which consists of enforceable rules governing relationship among states. So, law is controlling people, you know, all of us to behave in a certain way. Just behaving, conduct. Not telling us what to do, just how should we behave so that we can deal with each other. National law is between state. New Jersey, be nice to California. California, behave nice with Miami. You know, because we have a tendency, who's in Miami? People, they don't even know how to vote. You know what I'm saying? So these are the things, we have that. But that's fine when, you know, we're joking around. But nowadays, when you're dealing with the internet, you're going to see more and more people put parentheses joke because you don't know. Maybe it's not a joke, especially if you're, right, because people got sued. Otherwise, we wouldn't think of things like that. You have to make a happy face or a joke. So, and then, of course, national is what? Between state. So we have federal laws because they say, hey, New Jersey, don't discriminate, you know, people that come from Pennsylvania and they're black or white. Don't do things like that. You know, and we're trying to make uniform laws like the Uniform Commercial Code. You know, okay, New Jersey, I know you're much better in doing business than New York. However, there has to be some kind of standard so that the business people in New Jersey can deal with the business people. There's a certain behavior that we expect from each other. Expectation of behavior is so important. And you're going to see more and more legislation because of that. Okay, what is international law then? It's relationship between what? Nations. Big difference. This is the problem we have. And being that I know some of the things, you see why we have some of this problem. You know, because in our values in the United States is definitely different from Syria. It's definitely different from Russia. You know, and we put all kinds of labels, communist party, and it's nothing to do with parties and democracy, not really. It's just culture, it's just belief, it's just the way that we think is appropriate behavior. I'm not even using the word right and wrong because nobody knows what's right and wrong anymore. Appropriate behavior that is acceptable, what? By the reasonable people. And who are these reasonable people? A group of people that have little disagreement about the same issue. Now, when you did your midterm exam, didn't you find different opinions in your own group? Or they didn't care, so they want to get it over and done? I have to go out soon, come on, okay, that's fine with me, whatever. You know what I'm saying? Whatever, you know. But there's a tendency, and you're going to see it. This is why we have arguments. You know, this is why we have arguments, because we think that we have the correct way of doing things, and some, no, I don't think so. You know, and that's the thing. But this is relationship among nations. We try to get along. This is why we have the United Nations. You know, we try to get along. But even that, the United Nations, in a way, is trying to impose their belief or their culture, their way of doing things, you know, in other country. And where is the line? Where's the line? Where's the line? Nobody likes to see people getting killed. Nobody likes to get people that kind of thing. But do we have a right to tell, and think of business, the same thing. You know, in Japan, they do things different than we do it over here. We have individual freedom. We have freedom of speech. We can say things. We can change things. We got different way, capitalists. We got all different, we have a whole way of seeing situation. Perception again. Perception is so important. Okay, you get it that. International law is the result of attempts to reconcile the need, not the wants, the need of each country to be final authority over its own affair and the desire to benefit from the relationship. Needs, like they need food, they need clothes, they need prescription, not want. We have a tendency here in this country to think more of wants. I want white teeth. I want a bigger house, bigger car. I don't want to stop at the gas anymore. I want to get an electrical car. When you have a car already, you know, think about it. Because many times I have to catch myself too. I want. Or you hear the word, we deserve. There's not such a thing of deserving. Oh, you deserve to get away. Why? By you going away, you ruined that place. because now you're over there. You know what I'm saying? So I always tell that my kids all the time. What makes you think by changing this? Okay, source of international law. Now, source of our national law, United States, the Constitution, statutory law, common law. Those are the three ones, the important one. Okay, case law, first I go to the court, I complain I have a problem, I want to be made whole again because someone injured me. Usually first we have a case law, and then after a couple of years we make it a statute because it's not just good for Diana Walsh that went to court and made herself whole, but we want to make sure that in our society everybody's going to be treated equal, so we're going to write a statute. And sometimes that statute is unconstitutional because the government is stepping over their power because they're not supposed to be telling us what to do. That's in the United States. That's the thinking that we have over here, not other nations. So international custom, that's the source, international evidence. We've been doing this for so many years. We've been doing so many years. I remember when I went a couple of years to Italy to get some documents, you know, they don't like the EU. The Italian does not like the EU. The French people don't like the EU. And guess what they told me? Oh, we have been here for years. For years we've been doing things. We like our monetary, the lira. We don't like this whole thing of the euro, you know. What is this now, you know, bunch? They don't really like Germany. They really don't like to be told you have to change. And then they told me the only reason we became member is because then we get money from them. So now the money that came, and of course, you know how much money you need to build roads, and much money. Oh, at the beginning, you know how at the beginning everybody, well, whatever, at the beginning, whatever, you know. Oh, I'll help you, I'll do this, you know. And then next thing you know, okay, now pay back. Because nothing is for nothing. So now all at once that they're asking Italy and Greece and everybody to pay back, we don't want to pay back. Yeah, well, you know, and of course they charge interest too. So it's, I mean, it's just, I have no solution, so don't ask me, but I see the situation. I see the problem, and I'm saying, oh, thank God I'm not involved in that. Treaties and international agreement. Okay, what is international outside customs and culture? Agreements. United States makes agreement with France. France makes, and I remember writing one of these international contracts where we asking the company was making valves, and they were asking me to write a contract because they were going to sell it to Ireland. And they were asking Ireland then not to sell the valves to Iran, Iraq, most of the Middle East. That was in the contract. However, do we have anybody from this company that asked me to write the contract going to Ireland to make sure that they don't sell this stuff to Iran and Iraq? No. But it looks good on the paper. But there is no what? Follow up. So I don't know when we send all those walls if they're going to send it to, you know, and it was all things for, you know, making arms and stuff like that. The thing is, that's what I'm saying, that, you know, yeah, it looks good on the paper and they want to cover their behind because this way, if we find something that we're not supposed to be in Iran or Iraq or in the middle part of the Middle East, but we had to write that in the contract. You're not allowed to sell our goods or our products to these nations, you know. And this is where sometimes you see Cuba, the same thing. But does anybody really follow it? No. And then, of course, when we have a change of government, we have a problem. Because we as business, we made the contract with these nations, not with the individual business over there. We made contract with the what? The nation. The nation changes, govern. That means our contract is not valid. It's nothing. Piece of paper. So the business loses a lot of money when we have all these changes of government. Because they say, oh, don't worry, but we're still going to be your friend, America. Yeah, because you know why? Because we write the check. But it does not mean they will be a friend, because as soon as we do something that they don't like it, all at once, there's no contract. There's no anything. You know, I want you to know it's all about agreements. And as soon as you change a party in the agreement is void. The person doesn't even have to die, just not being in charge anymore. International organization, that's what the United Nations comes in a lot. You know, they're trying, we all are trying to live in harmony, to respect each other, to have courtesy. Common law and civil law system. Common law is us, United States, and civil law system is the other nation. So most of Europe, Latin America, Africa, Asia are based on civil law system. And civil law system is very similar to administrative law. I mean, we know what's so funny up there? What's so funny? Would you mind to share? We like something to laugh too. Lack of respect. Okay, now England, United States, and other ex-British colonies based on common law or case law. The difference there. All right, this is a chart that you have in your textbook too, and the PowerPoint, I got it, just to show you this is common law, and this is very similar to ours, that what we have case law. Common law is really case law because our judges makes law. Our judges makes law. And then if you don't like the decision, you can appeal it, and you can go all the way to the Supreme Court of the state, and you can go all the way to the Supreme Court of the United States. And then, of course, there's a civil law, and you see there are different countries, Argentina, Austria, Brazil. These are the nation. This one you see more countries that were under dominion of the British, pretty much, or the United States. Not so much ours, but United States, Singapore, Nigeria, Australia, Bangladesh, you see that. And then you see the civil law instead completely different. You see a lot more in that we're dealing with the business. The EU is civil law, completely different from ours. Does it help you? Okay, international law source of and principle, because it goes again, the most important principles and doctrines applied in the interest of maintaining the whole purpose. Like, you know, SOX is, the purpose is to protect investors. You know, Civil Rights Act legislation is for us not to discriminate. In this country, the law usually tell us what not to do, except for the Constitution. So these are the principle of comity, very important word. The principle of the act of state of doctrine. We have something like that between states too, but that's not as much important as an international law. And then we have the doctrine of sovereign immunity, which goes back to where the king can do no wrong. This is why in our society we don't believe that. You know, we don't believe a governor to stay forever and ever and ever. We don't believe a president to stay forever and ever and ever. We had a lot of problem with mayor, of New York wanted to run the third time. We do believe that, hey, you become too powerful, too much favors, the position's going to cause more corruption. Let's change. We believe in changing and clean up, you know, that kind of things. Very, very, very. One nation will defer. Okay, what does it mean, comity? One nation will defer and give effect to the law and judicial degrees of another nation as long as those laws are degrees. So what we're saying is, I'm going to respect your laws as long as your laws are pretty much similar to ours, because we still think that our laws is better than everybody else. You know, as long as, you know, like you don't go around killing people, there are certain basic things. And if you think about it, it always goes back to the 10 Commandments. You know, respect people. Don't rob things. Don't desire to have somebody else things. Be happy with what you have. And if you think about it, it's so interesting because that's what we really are saying here. You know, respect other nation. You know, they got people, they're not going to do things to hurt their people. We like to think that government is trying to keep us happy, the best that we can do, give us opportunity. But we have the Constitution, other nation does not. The government writes the Constitution. We didn't have a government until after the Constitution. It was just people, and the first president didn't even get paid, George Washington. This is why I thought it was interesting when they were asking about Romney if he's going to get paid, you know, because when he was a governor, he did not get paid. So, and he says, I cannot answer that question yet because he doesn't know if he's going to be a president yet either. Why do courts involving a foreigner law or judicial degree, two different things, You see that? Between the court decisions and the law that is written by the elected people does apply to this principle, which is the principle of comity. Courtesy and respect. Courtesy and respect. Now, maybe this is personal. You don't have to answer. Do you believe that we have respect in this country for each other? For authority? It depends, Janice learned. Depends who it is, and yeah, in a way that's true. You know, it's much easier, let's put it this way. Yeah, it is true. But you really, you know, to tell the truth, I remember very well when I first, this is 1960. I'm coming from a country that says it is democracy, Italy. And I met my American husband, and the first time we finally can go out, we have to be home 10 o'clock because, you know, things can happen after 10. So I have to be 10. And I remember he comes with his car, and he's so happy finally he can get me out of the house because before only sees me in the house. And I am standing at the door of his car on the side, and I'm waiting. And he goes in the car, okay? And then he comes out with his head, and he goes, "What's the matter with your hand?" I said, "Well, I thought you were going to come over and open the door for me." I said, that's the way I was raised. That's the way I saw things happening. That's the way this is. And he goes, "What? If something's wrong with your hand, yes. Otherwise, open the door and get yourself inside, you know." See, and, guys don't say a word. And girls. But, you know, and even for sons, when I told him, I said, "You know, do me a favor when you go out, have respect for the lady." You know, the times when the guys will stand up and open the chair. And of course, guess what my son says? All of them. Go ahead. Maybe you have the answer.
I think we would have more respect for ladies if they had more respect for themselves now.
I think I know what it means because let's put it this way. I grew up with 4 sons and my husband be the 5th one. You know what I'm saying? But one of the first things that my son says to me, "Oh, it's not our fault. You want to be equal to us. You want to be equal to us." You know what I'm saying? You want to be equal. So why should I wait, you know, open the door for you? You got 2 hands like I do, you know? So they didn't have any dinner that night. But anyhow, those are the things. But you see what I'm saying? Think about it. Do we have that? Because I do notice sometimes the difference between professor that comes from another country and professor that are still here. So it's very important, courtesy and respect. But I heard that too. I heard that. You know, like if you want people to respect you, you have to respect them, and then they respect you back. I heard that. You want to have a friend, you want to have friends, be a friend. Then you have, I heard that too. So the state of doctrine, that's another one. Judicial, now this is the court now. See, before it was because of, as a nation, we're supposed to respect their laws. Now it's the court decision. And you hear sometime on the news that we don't like the way the court decides, especially when it's our children that are getting hurt in another country, and the court decides that they committed a crime. Oh my gosh, we think they're wrong. Judicial branch of our country will not examine the validity of the public acts committed by what? Another country. So there is a thing that they even say to, you know, if you're going to be an exchange student, be very careful because our laws will not protect you in China. Our laws will not protect you in Italy, and be very careful. We cannot do anything. So if you commit anything, here you're innocent until proven guilty. Over there you're guilty and you have to prove your innocence. And it's a lot easier to prove your guilt than prove guilty you're not, that you're guilty and you're innocent. Much, much easier, because when you start having a label, forget it. It's very easy to change. Okay. In what circumstances in this doctrine apply the judicial decision of other country? When you think is applied? This doctrine is often invoked when? In expropriation and confiscation. What does it mean? This is so important because when the court make decisions, we have to respect the decision. And this principle of the act of the state, the doctrine, is uses in these two things, expropriation, and you hear it, they use it. They don't use this term, but you're going to see that in your multiple choice. What are the difference between expropriation and confiscation? Expropriation occurs when a property is taken by the owner, and if the government owns it, then has to pay just compensation for what is taken. Expropriation does not violate generally observed principle of international law. So, if the government takes a piece of land of yours, you know, they have to compensate you. Now remember, the other nation, they change government. So the old government get kicked out, you have the new government, they're not going to do that. It goes back to that again, like even in Europe when they used to marry someone so that they can become emperor and have more nation under, or if they had a war, everybody in the nation became slaves to them. You know, we have a little bit different in this country, but expropriation is so different. And if we're going to have business in another country, this is very important for you there. Because you have business, you own property, and next thing you know, if the government changes, then they should be compensating you, which usually doesn't happen. And this is where I want you. Confiscation occurs when contrast the property is taken, no adequate compensation. International principles are violated when property is confiscated. And they do that. They do that. They take the things away. They just take it away. Because they first of all, in this country, to tell you the truth, really, we do not own anything. In other countries, you do that. For example, my father wanted to bury in Yugoslavia, former Yugoslavia is Croatia now. We don't buy lots in the cemetery. We pay rent because the property is of the state. Here, we think we buy it, but we don't. Because when you buy something and you have to file it with the court, that means the court is giving you, or the state of New Jersey is giving you a privilege to buy a house in New Jersey. They're just keeping records. If it's your property, you wouldn't have to keep records. So in a way, you don't own anything, not just because of the mortgage, but also because that's the law. It's a privilege for you to have property in New Jersey. And the court is keeping record. You file everything. So this is why we have problems with eminent domain. Okay. This is very important because this doctrine exempts foreign nation from jurisdiction in the United States court. So other nations cannot be adjudicated. They cannot be taken to court in our courts. This is why then we have the international courts in the Netherlands, which is very interesting because when a nation is committing a crime or their government, what are we going to do? We're going to put all these people in jail? We're doing boycotting, you know, and when you boycott, who suffer really is the little people, the wives, the children, not the people up there. They still have the nice, you know, homes and comforts and meat and stuff, and prescriptions. As a matter of fact, we hear there was one of the ministers that needs surgery and he went to France. Well, why don't you use your own doctors? He's going to France, and we have some of the governors of other countries come over here. Well, why don't you stay in your own country, like the same one that you have for your people? You know, so these are the things that I want you to see sometimes how difficult it is because it's always the society that ends up paying for it, for everything. But this is so, to me, bothers me sometimes. The Foreign Administration Act expanded jurisdiction, United States Court, creditor authority. So when it comes to money, when it comes to credit, all at once we, United States Court, judicial, state of doctrine, we said, wait a minute. Yes, I know that the nation is immune, that they can do no wrong. But when it comes to money, creditors, when it comes to exchange of commercial activities, we're going to have to do something here. Because we in the United States are protecting people that. Because we do not own business, the government. People own business. So we're going to have to do something because here's our people there in other countries doing business. Next thing you know, they have to have the opportunity to be heard in our court to protect the individual, and it's nothing to do with the government. It just, and that's what the court interferes, and not the government. 1976, the United States Congress codified the rules under which foreign states are immune from lawsuit in a Foreigner Sovereignty Immunity Act, the FSIA, 1976. This act governs the circumstances in which an action may be brought in the United States against a foreign action. So under this statute, to protect the American citizen, if a foreign nation is hurting us, we have the opportunity to be heard in in United States court. But it cannot be anything to do like with war. It has to do something with commercial activity only. And the thing that in that statute does not define that. Congress decided that the court and not the Department of State evaluate claims of foreign sovereignty immunity. So all at once, it's not the department, it's not a regulatory agency, it's not a commissioner, but we have to go to court to find out whether the United States, the American citizen or the business was injured by another nation. Another nation, not another company. Many foreign states have sought to characterize what was essential commercial activities as official government functions that are immune from suit. So even if it is a commercial activity, the other nation doesn't see it as a commercial activity because most of the government owns the business, and therefore they see as what? It's a government issue, not a commercial activity. The Foreign Sovereignty Immunity Act does not define what constitutes a commercial activity. However, the courts must decide whether a particular activity is governmental or commercial. That means you have to go in court. And again, it's very unlikely the economy of the United States, which is primarily controlled by private interest, the economies of many other countries, particularly developing nations, are often extensively controlled by the government. Extensively. This means that if a United States plaintiff sues a business or an institution that is controlled by the foreign government, the foreign defendant, which is the nation, may assert the defense of sovereignty immunity under the Foreign Sovereignty Immunity Act. So be very careful as a business person. In this situation, a United States court cannot exercise jurisdiction over the dispute unless the plaintiff can prove, among other things, because there's probably other things, that the defendant action constitutes a commercial activity. So we go and work or be asked to work for a company, or especially during the Iraq war, we contract. We have all kinds of contract over there. We had people coming or going from this country to go over there, and some you heard on the news it was corruption. Some did not work very good. And next thing you know, things happens over there, and then was that a commercial activity or was that a governmental issue? Therefore, the American worker or the American employee could not be taking the case to court to be protected under our laws in the United States. What, however, is then a commercial activity? And you're only going to learn by cases. Just like the legal duty is by cases that you know. Remember I gave you a list. It's because of special relationship and because of contractual relationship. So pretty much almost everything we have contractual relationship, because as soon as you're making an offer, and whether the acceptance is yes or no, you may have a contractual relationship. Very important for you to remember that, because you're dealing with contracts all the time. And you want to know whether you have a legal responsibility not to hurt someone or stop from hurting someone. And this is where I made the outline for that, especially when you're an accountant, and lawyers have the same thing. Okay, case. On what basis may a foreign state be considered subject to the jurisdiction of the United States? What make the distinctions between activities that are sovereignty or governmental and commercial character? Fact. The plaintiff, Mr. Nelson, filed an action for damages against the Kingdom of Saudi Hospital and the hospital purchasing agent in the United States. So here there's going agreement here, but this is the going in court. The purchasing agent had, at the direction of the Saudi government, recruit the husband through advertising in the United States to work at a hospital in Saudi Arabia. His new job entailed monitoring facilities, equipment, utilities, and maintenance system to ensure the safety of the patients, hospital staff, and others. Shortly after the employment began, he discovered numerous safety violations and defects throughout the hospital, of which he promptly informed his superiors and the Saudi government commission of the infraction. And he was asked to ignore the problems by the hospital. So he's doing his job. He sees something that's not safe enough, he's reporting it right away. While working as a safety inspector in a government-owned hospital in Saudi Arabia, he was arrested, jailed, unlawfully detained, and tortured in retaliation for reporting safety defects. The Court of Appeals found subject matter jurisdiction, concluding that the husband recruitment and hiring was a commercial activity of Saudi Arabia and the hospital carried on in the United States, and that the Nelson action was based upon these activities within the meaning of the statute. So here we go. Is it a commercial activity or is it a governmental issue? Because if it's government, the hospital is owned by the government. He was doing work there of the hospital, but is it commercial activity or is it a governmental issue? Well, he was hired, but you know, this is very difficult in that area. It's a lot more than a gray area beginning to be. The Supreme Court of the United States concluded that it did not, holding that a state engages in commercial activity where it exercises only those powers that can also be exercised by private citizens. Yes, go ahead.
I have a question. You know how the U.S. has some land, like compounds
Mm-hmm.
in Saudi Arabia? Do our laws transfer over to like those compounds, or do they follow Saudi laws?
For our soldiers?
No, like it's for like a lot of they're regular civilians in the U.S. They just live on a compound, let them like work on the oil field.
The things that, no.
So it's still Saudi law,
Yeah.
even though it's like U.S. compound.
Right. And you bet your life the agreement was clear on that kind of thing. And they had to probably negotiate. It might took a couple of years before, because what they did is probably compromise. Compromise. So here is a situation, you know, does whatever it was this guy that was doing the inspection, can that be exercised by private citizen? The court held that the alleged tortious action of the Saudi government against the American employee were sovereign in character, and thus the Saudi government was immune from liability under the Foreign Act. It was not a commercial activity. What was he doing? He was inspecting safety, which is more what? A government ordinance and law. It's not a business. There's no exchange of any products. It's really a government issue, you know, just like we have OSHA, you know, and next thing you know, you're hired by OSHA, and you're an employee of the government. You're not really a regular citizen anymore. And even the other day when I was talking to someone, when you are a citizen, you are protected on the Constitution. But if you are a public employee, then it's a whole different thing. You're not whistle, or you're not doing things like a regular citizen under the Constitution. You have to obey the law of the company or the public employer. And if the public employer says, I don't want you to do this, you cannot say, oh, it's freedom speech and under the no, because at that time you're an employee, you're not acting as a citizen. Very important for things like that. The Constitution is protecting we as the people, the citizen. And this is, we have a problem because not all the people are even citizen. This is another big discussion we had. In Janani versus Kuwait University, the plaintiff in the case was an American citizen, George Janini, and other former professor and employees of Kuwait University. I don't think I'm pronouncing it. When I pronounce something, it doesn't sound right. The plaintiffs were terminated from their position when the government of Kuwait, following Iraq invasion, change of government, in August 1990, issued a decree stating, among other things, the contract concluded between the government and those non-Kuwait workers who'd work for it shall be considered automatically abrogated because of their impossibility of enforcement due to the Iraqi invasion. So you know the professor's going to, the plaintiff sued KU in a USA court, alleging that their termination breached their employment contract, which required 9 months notice before termination. So they changed the government, they got invasion, so right away they're making a new law. You're going to be terminated if you're not a citizen of Kuwait. And they say, wait a minute, this is wrong because according to the contract that we had, you know, you have to give 9 months notice. And they didn't give me any 9 months notice, so it's a breach of contract. Now, they changed government. The plaintiffs sought back pay and other benefit which they were entitled under the contract. The question before the court was whether terminating the professor position constituted a commercial activity. Because if it's a commercial activity, then they can have the case in United States court. If it's not a commercial activity, goodbye. Hope you have a nice summer. That's all we can do. The court held that it did. In this case, it's a commercial activity, and the important thing is the reasoning. They were professors in a public school or government. The court concluded there is nothing peculiar sovereignty about unilaterally terminating an employment contract. Nothing to do with a government issue. Private parties often repudiate a contract in everyday commerce and may be held liable therefore. See the difference here? Because the other one was also hired. He was also an employee. But he was doing what? He was just make sure that they complied the local law, and apparently he didn't think that they were safe enough. And next thing you know, don't interfere with the business the way they run their nation. They define safety different from what you think it is safe. But here, they were hired to teach, and next thing you know, they're changing government. They're making a new laws now that, you know, anybody that is not Kuwait will be terminated. And this is fine, but you have to give me 9 months notice according to the employment contract, not according to the new law. But we have a contract here, and the contract was before the new government or the new laws. So that's why they call it then regular people, they can do that. This is another one. This is for you for business. Be very careful. An American corporation, Unicol, found itself when its joint venture in Burma was accused of mistreating its workers. So do you know what a joint venture is? It's when what? Two companies get together to do one specific project. It's not like all kinds of business. So one of them was a government and one was the United States. Unicol had entered into a joint venture with an agency of the Burmese government for the purpose of constructing a gas pipeline in Burma. A group of Burmese government and Unicol Corporation alleging that these employers had violated human rights. The plaintiff complained, which is the employees, that they were victim of rape, forced labor, involuntary relocation, and torture. They don't even talk about not getting paid enough money. They talk about physical pain. The United States District Court dismissed the claims against the Burmese government, holding that the claims against the Burmese government did not fall within the commercial activities exception of the Foreign Sovereignty Act, Immunity Act. What does it mean to you? Is it a commercial activities or no? It's not a commercial activities. Should the United States business workers be held liable for human rights violation even if they are unaware of such a violation? Yeah. Because then the United States company was liable, even if you do not know. So this is one of those things that is very interesting because we do have writing contract. And I know that we write those things in a contract knowing that the nation will violate because nobody's following it up. Unless somebody then goes to court, and then we decided whether we should even listen to the contract. But most of the time, people don't have the time or the money to go into all that. It takes a couple of years. In the meantime, you continue to be tortured. You continue to be what? Be mistreated. You continue to do all kinds until, you know, people decide whether it's a commercial activity or not. Because in a way, we have no right. So we have to be very careful when we get involved in business with other nations. Because their laws is different from ours. And who are we to say that their laws are no good and ours are better? Just different. Just different way of getting things done. And you know that some people need to be tortured to get things done, and some people you just look at them and they get things done. You know that, you know. I mean, and when you're used to it, you don't even know any other way. You know, this is why when I took my master's degree in human relationship and social, there are some women, their wives that gets beat up by their husband. They think that that's normal because why? They believe, oh, he does that because he loves me. You know, because that's it. You know, I mean, and you don't know that's the way. You know, or whatever. It's interesting because perception. Remember, perception. Oh, it's amazing. Or whatever reason you can see they perceive it. You know, I'd rather being beat up than being a single mother. Okay, fine. But as long as you know that, that's okay with me, because it's your choice. But the fact that some of these people don't know it, and then of course many nations don't want to educate the woman. And I have to tell you that is so true, because before the woman became educated and becoming independent and having a career, we didn't have as many divorces. Study shows that as soon as the woman makes more money than the husband, within few years you have a divorce. Study shows that we had no pro bono services, legal aid society. 1960 they opened up a legal aid society because they thought for the poor people can go to the court like they were thinking of business. Number one cases was divorce. They were surprised. All the poor women divorcing their husband using the legal aid because they didn't have money. And child abuse and raping of fathers, incest and stuff like that. They expect a contract, they expected employment because these people cannot afford attorney. They expected business cases, and next thing you know, they're finding out it was all about divorce and incest and rape and within the families, between the poor family. They were surprised. Very surprised, because I guess business always have some kind of money, and now the legal society has to say you have to be on SSI or Social Security, otherwise we want some kind of income, not no work at all. So, and that's the case. I didn't want it. Questions? What is international business transaction then? Yeah, and what kind of business transaction? That has to be what? Some kind of commercial activity, something that has nothing to do with government rules and regulation or local ordinance or the way they run their countries, or complaining, for example, that I'm an American citizen and I work in Taiwan or something like that, and next thing I'm complaining because they don't pay me enough money because I'm finding out on the net that people in the United States, no, forget it. That's going to happen. That's the way it is, and that's all there is to it. Very much difference. If there's any binding agreement or contract between two or more parties not having what? The same nationality. What are the primary methods for resolving international contractual dispute? Because that's what it is all about. Litigation and arbitration. Litigation and arbitration. And litigation is overwhelming. And there are cases that I covered so many times that people in that country or other country, they rather have the cases argue here. It's American company hurting them because they're exposed to chemicals, for example. So the people are hurt and they want to argue here. Why do they want to argue here? They're going to be more protected, there's no question. And why would the company instead want it over there? because even if they win, it's going to be a lot less money. You know, and there are cases, there are really cases. And of course, one of the things that was interesting, there was one case, Shell gasoline station again with the Costa Rica. The company says, don't have these cases argue here, because there was taxes. Because the dissenting judge says, you know what's going to happen here? Then nobody's going to want to have a corporation in Texas because the court won't argue there. But if the court says, no, we're going to argue the case in Costa Rica, then, because I know now Texas is going to end up with more money. It was very interesting. The only thing they thought about, oh my goodness, now no corporation is going to come in Texas when they know that the judicial system is going to make all these other countries argue here because it's going to be more money. They're not going to come, so we're going to have higher unemployment. These are the things that is, and yeah, possible. I'm not saying that's not possible. But again, nobody even thought about it. Hey, how about stopping, exposing people to taxing instead of how much money it's going to cost us? And so arbitration is the best. Types of international business operation. Now, this is types of international, and it's all agreement. And you heard that in business, international business. Exporting through an agent, a foreign distributor. This is why agency law was important, because sometimes company here hire somebody maybe in India to do work for the company, because the people in India would be more willing to work with somebody in India, the language, the culture, the food, whatever, the conduct, the behavior, but they don't want that person to be the company, because then if there's any problem, then they sue the company. They want it to be independent contractor. They want it so this way they don't have to pay for any lawsuit or anything. And it's so difficult because the court knows that the company wants to do that. But the only time they have to make the decision is from the evidence they receive. They cannot say, oh, cause good company, I know why they're doing that. They have to have evidence. So, and there's so many cases that happens. A foreign distributor. Manufacturing abroad. Through what? Licensing. That's big. Franchising, intellectual property. And I remember when I was a corporate attorney that at that time we got softwares to keep record of employment benefit and payrolls and different things, and I had to review the contract. And usually in the contract it says, we're going to give you the license for this building, the address, an average approximate how many people is going to use it, and who has the authority to use it, because not everybody has the authority. Sure enough, the president of the company, which I can see him doing that, he's asking the IT people, make a copy of that software, and we're going to give it to China because that's where we're going to use it. We have a branch of Givaudan over there in Roche. They find out that was what? Violation. Because in the licensing agreement, it was only what? The address of the United States, Clifton, New Jersey. And here is now, he's thinking that to download it, make a copy, transfer over there. It's the same company, employees over there, it's just a subsidiary over there, and the company got into trouble. So, because why? Everyone that is using the software had to pay extra. So we were supposed to say, we're planning to have another 3 subsidiary to use the same license, then we wouldn't have to have the penalty, and we had to go to court and all kinds of stuff over there, over here, because it was commercial activity. Franchising, investing in a subsidiary joint venture. Sometime, I know at the company I was working, they used to do research in France, and we got into trouble even there, but the case was argued over here, because it was cheaper to do research over here. We don't mind to spend money as a corporation in advertisement and in marketing. And we spend a lot of money in advertising, in marketing, even before the product is approved by the Food and Drug Administration. We have a lot of problem in that area because we want to hit this, right away that people start buying big company. And the thing that happens sometimes that by the time we manufacture all this product, and then after about 3 years, the Food and Drug Administration finally tells them, no, you cannot. So what are we going to do with all this baby formula? What are we going to do with all the stuff we have? We send it to what? Developing nation. We send it to developing nation. And the thing that I always question is, if it's not good for the people in this country, why are you sending it over there? Well, what do you want us to do? Throw it away? Yeah. But they're thinking what? Well, I guess we better get some money out of it. And sometimes you hear in the news, you know, we send formulas and the mothers, instead of nursing, they use the formula, and then the formula has all kinds of bacteria and different things. And this is just a few things sometimes. And sometimes we're too strict, maybe, I don't know. I don't know. I'm glad that I don't have that responsibility. Comparative legal system, you have, again, I mentioned that before, judges and procedures. The judges in this country make decision. The judges in civil law or civil action, if you want to call it, does not make decision. They are inquisitory. Our system is adversary. Tort and criminal laws, contract law difference. Oh my goodness. I gave you a chart, I think the first semester, but I have, I think, a chart over here. We have the Uniform Commercial Code when we sell goods and product versus the convention contract of intentional sales of goods. And you're going to see the difference. An employment law difference, definitely employment. In employment law here we have, remember, no feudal system, no master and slave. We have what? Contractual relationship. Other countries, you don't have contractual relationship. It's more paternal. The company is more like the big guy that's going to take care of you forever or something like that. You know, it's just completely different. That mentality is still there, even if they try to change, but very slow. So here, international sales of good contract, application, goods, any sales. Here, only international commercial sales of goods. So you're going to have something that you manufacture here, but it's a good, but you're going to sell in another nation, then it becomes an international commercial sales of good. Here, any sales of good goes on the commercial good. That's only when you sell into another nation. The parties only applies to merchants. And the code has a definition who's a merchant. It's not something that we think in our head who's a merchant. Applies to any party. Merchant often held to a higher standard. So here in the United States, anybody can sell goods. Uniform Commercial Code only has a higher standard if you are a commercial vendor because you know better about the product. But we can sell. This is why in eBay we sell all kinds of things. You don't have to be a merchant. Internationally, you have to be a merchant. Not anybody can sell goods in Spain. I cannot sell goods to someone in Italy if I want to. I cannot. This is why we have eBay, and this is why eBay pretty much all the time defend themselves as what? As internet service provider. Like we are only the connection between the people. But there's a lot of litigation with eBay because that's why they're changing all the time. They're changing all the time because there's a difference between international sales, which is products that go to, and of course eBay is global. I mean, you can exchange things with people in Spain and in all kinds of countries. I don't get involved with that, but I hear things from one of my sons. Acceptance, mirror image. You remember in contract, what does it mean, mirror image? Exactly the same thing. Like, you know, you look in yourself at the mirror. You don't like what you see, especially early in the morning. I like a nice dim light. But anyhow, you know, that's me, you know. Mirror images, you don't have any battle, you don't have any counterclaim, you don't have it. It has to be the same thing. It has to be, that's it. There is no negotiation, there's no anything, there's nothing. So instead here you have battle of the forms. There's a battle. Well, how about if you change this? Counter offer, remember? Rules, non-material change may vary. It's okay. We can negotiate on the day. We can negotiate on the time. We don't negotiate much in the price, but even that, we battle. We argue. We counter. We have, because again, there is not such a thing that I know that I'm a merchant. This is why Uniform Commercial Code expect a higher behavior from the merchant. But I can sell goods. This is why when you're going to buy a car, sales, and it's as is, well, if it's a merchant or if it's the seller, We expect it for, why are you selling it is? Maybe you know something that you don't want. You don't want to show us. And many times, you know, well, it's as is, I don't want to be bothered. But we have still negotiation. We still make negotiation. We still say, hey, you know, we're going to get inspected. I'm going to bring the car to a friend of mine if it's a house. And then we find something that it's not working. We're going to ask the seller to give us extra money to pay for fixing it. And you hear the seller, didn't I tell you that I'm selling this as is? Yes, but that doesn't mean battle the form. Just because you say it doesn't mean anything in this country. We still have what? Equal opportunity to negotiate. Other countries, we don't do that. Now, correct me. When international student, when you go shopping for something in a store, do you negotiate prices? Yes? Here, we don't. So I remember going to Massey, going to be married outside and pronouncing the word sheets correctly. You know, next thing you know, he tells me that's the price, and I'm saying, are you kidding? That's not really real cotton. I'm not going to pay for this. My husband-to-be just walked out. I should have known that. I cannot rely on him. I'm negotiating the price because what do you think? I'm a jerk to pay all those money? You know, it's only lately that if you find the same thing in another store and they have it higher, it's only lately. 1960, you didn't have anything like that. So this was new to me that I could not negotiate. And I remember, well, he says to me, if you don't like it, you don't have to buy it. Here we go, choice again. Yeah, but I need sheets. You know what I'm saying? So you go to another store. Why should I go to another store when this is closer one? What am I going to spend? Half an hour now to find another, you know? And of course, in the internet, it's a little easier because you can switch sides. But it's overwhelming. Everything I negotiate to this day. To this day I negotiate. I think by now they know that Diana's going to negotiate, so they charge me more money at first. Because this way, I think they say, oh, here she comes again. You know what I'm saying? Let's charge her more money so when you negotiate, we come to the money, we plan to do it. But, you know, these are the things. Here we don't. You know, we just don't argue. We just accept it. That's the price, and that's all there is to it. You know, the only thing we want is to make sure it works. And we think that the more money we pay for it, okay, we'll see what Verizon is going to do. Okay, consideration. None need to modify contract. In the United States, ours, instead what? We need it. Why we need consideration when we want to modify contract? What does it do it when we modify a contract? We have a different contract. We have, you know, when you have a contract and I have a consideration, because the consideration is to show that what? I'm in business, I really want to have a relationship with you in business. And next thing you know, we're changing some of the thing. Well, if you're going to change, then you have a new contract. In international, you don't. Because first of all, they don't change things. That's, you know, that's the way they do things about it. And that's why we believe that our contract is better to protect our money, you know, because we are used to be able to battle. We are used to say, hey, come on, you know, we just do that. And here, no writing is needed. In the United States, anything over $500, you have to do what? Write it. That's why you know. Regulation, here goes, good old laws. International business activity. Nation imposes laws and control to restrict or facilitate international business. I enjoy so much teaching international law for one semester. I remember doing that. We even went to the United Nations building. And it was so interesting because you see how every nation wants to keep their product first sold. So don't buy product from other country. First buying ours, and then when we don't have anymore, then you go and buy the other one. And you see all the different thing we do because we want that. And at the same time, other countries sometimes sells goods over here cheaper so that we sell cheaper, we buy cheaper, and then the government stops that nation really because you say, hey, that's no good. Then nobody's going to buy our product. And of course, we think our product are better. Investing in a subsidiary or joint venture. There's all kinds of regulation to do that. Export and import controls, quotas, tariffs, anti-dumping duties. But you know, this is going on all the time until what? Somebody gets hurt and takes you to court. Somebody gets hurt. This is why be very careful when you're going to get involved with international business, don't give all kinds of money as a deposit. No, the minimum you can, $1. I don't think so. But I recommend that because it's one of those things that we do these things, and we're talking about millions here sometime in business to get cars and to get food and this is where sometimes I feel so sad because we have plenty of food, and because of tariffs and quotas and all the other thing, we cannot send the food to people that don't have any food because it's a nation by nation situation. That nation, pride, if you want to call it, I don't know what it is, but here we pay the farmers sometime not to plant things because we don't want to have too much what? Grain. And why can't we, with the extra grain, then sell it to other nation or even give it away as a charity, make it income tax deductible? I don't know, something like that. But I'm not running that place, so I just have ideas, and ideas are very cheap. Okay, so tariff, anti-dumping duties. What is dumping? Dumping.
Very low.
Yeah. And we do it because they manufacturing all this stuff and they want to sell it over here. And why they want to sell it over here? Because we end up buying it. Because why? We want to, not because we need it. We want to. There was a time in my house we had 4 cars in the driveway. And if I wanted to take my car out of the garage, I had to wake up all these people in the morning to get their cars out of my way. Oh, Mom, why don't you park in the street? Excuse me, it's my house. I like to keep my car in the garage because they thought if I keep it in the street, I don't have to wake them up. Because this way they don't have to move the car. And they used to move the car half an hour later. So I used to think, what, did they need the car? No, they didn't. They wanted to have the car. They wanted it. It was nice. It's almost like freedom. You know what I'm saying? Oh, freedom to do whatever I want to. I don't have to say, Mom, can I use the car? Mom, wait. And then I would say, come back home a certain, I can, I guess it's the first thing you own, whatever you want, but we do that once. Most nations minimizing trade barriers. So I remember when we start having all this agreement NAFTA, I remember that, and the unions were very against it because of outsourcing. And I remember that they were con and pro, big argument. I remember that because I was teaching international law, and I would have somebody from the American business and somebody from international business to come. European Union. That's why. Why do we became a nation? Why did we become a nation? We were 13 colonies.
We didn't want to pay taxes.
What is it?
We didn't want to pay taxes.
We didn't, yeah. But why? We had different currency, 13 colonies. We had different currency, different languages. We got together as a nation because why? Commerce. 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 It was easier for people from goods from Europe, from India, with the boats, I don't know if they use rowboat going Atlantic, but they didn't have all the internet and all the flights and everything. But that's what we got together. And the EU did the same thing. They can go from one nation. It's amazing when within 2 hours you are in another country, another language. So they say, okay, why don't we get together? Because then it's easy to transporting goods. You don't have to show your passport all the time. You don't have to, all at once is different. Like when I went to France, and I remember I want some meatballs, and they says to me, you want Italian food? I says, yeah, well then go to Italy. Here instead, you can walk down the street in New York City, you can have, and I know what they were saying. Hey, we're not going to go, we French food, you want Italian? Half an hour, you're in Genoa. And I said, well, are you discriminating? Yes. They told me yes, because our food is better than yours, and next thing you know, we start arguing, because I think it. North America Free Trade Agreement. Free Trade Agreement. Don't get confused because it's not free. But it sounds free, doesn't it?
Sounds nice.
Now, the European Union is a lot stronger than all these agreements we have. We have these agreements with South America. We have with Canada. We are not as together as the EU. Because if you notice the EU, you hear Germany is pretty much in control. We don't have any, we are not United States in control. As a matter of fact, because maybe We know we are more affluent, more powerful, more richer. We try to be more timid, if you want to call it. We try not to say, do it my way or else. I wish sometime we would do it. Because we are affluent, we are more powerful. We have, you know, if you want to, this is why maybe we are arrogant, because we have a better kind of life. We are great in everything. We have more money, we have more crimes, we have more divorce. We're number one in everything. We're consistent like that. That's what makes everybody laugh. Bribery too, bribing foreign office officials. That's something that you learn in the first semester. Foreign corrupt practice. It's prohibited. The United States corporation cannot pay officials in other countries to get a contract. Now remember, most of the business is government over there. They think there's nothing wrong. But and sometimes it's an American company that takes an American company because this American company gave gift. It's us fighting with each other for that. It's not the other countries that are going to take us to court. You bribe, you know. No, it's us that we're taking. It's almost like brother and sister. You know, do things like that. And it's true, we do it. You know, because we got the Constitution. A poor company or a smaller company will not be able to give more money as a gift to a nation so that they can get a contract or to do whatever. And therefore they say, well, under the Constitution we don't have equal opportunity because we cannot come up with $19 million gift. We cannot come up with $6 million gift. So therefore it's illegal. And of course the court was very idealistic. The court says, yep, you're right, that's illegal. Because we want other countries to buy our good. Why? Because they're good and not because what? We are nice to them and buy them gift. Because when somebody gives you a gift, don't you think that's a nice person?
Yeah, you like it.
But did you ask whether the gift was stolen? Because maybe you know, now they start making problem because of that. They think you did not know because you didn't ask. So every time now they start saying you're supposed to be asking if that, because you're going to be what? Conspiring to the criminal situation. And I'm thinking, oh, can I see that? You know, they give you the engagement ring. Did you steal this one? You know, I want to see the invoice. You know, where is it? You know, that kind of, oh God. I mean, it's going too far, but I understand it. I understand it. I can see why. Because we can't trust anybody. Okay, now listen to this one. This is something to do with transportation. Agor Apparel Company buys fabric in the United States and ships it to Mexico to make pants. Any of you have pants made in Mexico? This is your case. The trousers are sewn, perma-pressed, and shipped back to the United States. Under a federal agency regulation for a branch of government, goods with the United States components that are assembled abroad and reshipped to the United States are exempt from a duty that is charged against other incoming goods. So what kinds of behavior is encouraging this one? Yeah, and by what they're trying to do, outsourcing and then ship it back here. Why manufacture something or have pants sewn in New Jersey? Why not send it to Mexico? Because then when we resend it over here, we pay even less money. We don't have the same duties. We don't have the same tariff. I mean, very interesting because of that. And this is going on. Okay, no problem. The United States Customs Service levy a duty on Agor pants, however, under a regulation that deems all perma-pressing operation to be an additional step in manufacturing, not assembly. Did I tell you words? Okay. All at once, perma-pressing is not part of the assembly to put the stuff together. It's what? It's a whole different thing. It's an additional step. So when you're putting the pants together, but you're using perma-pressed material, you're an extra step there. You're not just sewing them together. You're putting now an additional step to make it perma-press so we don't have to iron. So it's not part of the material or the fabric. It's an additional thing. So this is why then they charge Agor the duty. So what do you think Agor's going to do? going to court, okay? Oh, I love this. I love it. Edgar filed a suit in the United States Court of International Trade against the federal government seeking a refund. So here is an American company have outsourcing, reshipping here. Our government is charging them an extra fee for duty because of that. So they're suing in the court of the international trade because it's an international commerce transactions, our federal government, okay, the customs. Edgar argued that its perma-pressing was part of the assembly process.
What is perma-pressing exactly?
It's you don't have to iron your pants anymore. It's a special thing in the material, because I always look for that.
Like a material?
Yes, it's probably like a chemical, I think. It's something that you put in the material, you know, like instead of being pure, and they make it someplace that it, you know, it doesn't wrinkle anymore. Sometimes it's good and sometimes it isn't, because sometimes I think these perma-pressed, and you see the shape sitting down. Oh, I'm not going to go into design that thing. The court ruled in Edgar's favor. And the United States Court of Appeals for the Federal Circuit affirmed. The government appealed then to what?
Going all the way to the top.
Okay, for perma-press. Okay. Issue?
These are the pressing issues.
Yes, this is a pressing issue. You want to make it permanent. Should the regulation issued by the United States Customs Service be enforced? What do you think? Is a perma-press really additional, or is it not part of the assembly? That's why I like law. I love to find out. You know, then we argue, you know, and then we find out, oh, the court was wrong. Okay, because they didn't agree with us many times. Decision, yes, the United States Supreme Court vacated the judgment of the lower court and remanded the case for further proceeding. Reason, the Supreme Court acknowledged that Congress authorized the United States Treasury Department and the Customs Service to administer the tariff regulation, which were the product of notice and comment rulemaking, which is another procedures. Okay, the court held that without language to the contrary in the statute, there isn't anything like that, or the regulation, the tariff classification were entitled to what? Judicial deferences. That's a passive court. Well, we don't see that perma-press in the regulation, therefore what? It's not part of the statute. Watch it, some more says. Why do you think the courts give deference to respect or submit to administrative agency rule? They're saying, you know, we're not going to decide this. We're going to give deference to what? The Customs Service and the regulation. That's a passive court. When they don't come, because they can make the decision. It just says, you know what? It's almost like in a family. You had the experience. You went to your father, and your father says what? Give it, yes, mom. Or you go to your mom, and you don't like what she says, you go to your dad. That's deference. So you don't want to make the decision. I don't want to get into trouble. I don't want to start World War III. That's what the court did here, and they do it a lot. We know when it's a passive court, and we know when it's an active court. And then, of course, we complain sometimes when we have an active court, like who's this court that makes decision for the people? We did not elect them, so they have no right to tell us what to do. So you see, you have argument both ways. So I feel sometimes I enjoy it just because of that, because you never have right and wrong answers. You know? So there is to it. Why do you think they did that? Why would a bunch of judges, Supreme Court, 9 justices, says, I'm not going to interfere with this decision. I'm going to let the administrative agency make the decision, which they made a decision already. It is additional. But why the court would do that?
Would it create more problems, though? More cases? More issues?
Oh, yeah, sure, because then everything nowadays, they put all kinds of stuff. But that's because we want more money anyhow, so. We really don't want people to go outside. We really want people, corporation, to use people here.
Yeah.
So this is why we're doing that kind of thing. But why do you think we move it to the administrative regulatory agency? Why are we thinking here? Who's the court? Who's the justices? They're lawyer, right? Do they know anything about fabric? They really think, well, hey, they have expert. They probably engineers. They probably are specialized in that area, which is true, you know. That's why they don't have to be lawyer in a administrative agency. It's very interesting because of that. It's almost like a little corporation specialized in this area. That's why I'm taking that. Deference is acknowledgement of the great expertise of an agency. Administrative personnel tend to be expert in the field. They have the time and the money to devote themselves to detail. And we have a lot of them. Okay, commercial contracts. Oh my goodness, this is where the problem really comes up. Accounting, this is something you have to pay attention because it's something to do with money. Money system, foreign exchange rates market. You're doing international transactions, watch it with the money. Currency, it's overwhelming. There was one summer that I went to, spring, I went to Israel with my American son. And every day, the price of Coca-Cola was going up. They don't have diet. And they have Coca-Cola in a glass bottle, you know. In the tour, we had somebody from Lebanon. And he knew some of the people in Jerusalem. And because he knew the people at the deli or some kind of, yeah, I guess restaurant, the guy was selling to him cheaper. So he buys all this Coke instead of buying at the restaurant or at the hotel because it was every day $1 more, $2, this little tiny bottle. So capitalist son goes to the guy in Lebanon and says, oh, why don't we make a contract? You know, you buy all of those Coca-Cola because you're the friend and he's going to sell it to you cheaper. You know, and then we're going to sell it to the motel, you know, to the hotel and charge them so that we make all the profit. This is vacation. You know what I'm saying? I can't believe it. But here is a situation that it was so interesting. There was a binding relationship here. Because you're one of us, we'll charge you a lower price. You are tourist. You are tourist. You are coming from America. America has money. They don't care to pay for Coca-Cola $1 more. This is why the FBI agent got into trouble. Remember a couple of months ago, or maybe more, 6 months, when they went to Brazil and our FBI agents had some fun at the hotel with some prostitution, and she was going to charge him $800. And he says, go jump in the lake. I give you, what, $200. And she went to the police because he's stealing her. And why you think she charged him $800? Because she knew he was what? An FBI agent, and he's going to have it. Because I don't think she's charging the Brazilian $800, but the FBI agent, how they have money. They have this thing that we in the United States have money. They don't know that we work 3 jobs, but we have money. You know what I'm saying?
When I went to Italy, Coca-Cola in the bottles is $5.
Oh, now it's brought, yeah.
Unbelievable, $5 for a little thing of
Mm-hmm.
Coca-Cola.
And then what happens?
They're making hand over fist money.
Well, it's a lot to do with tariff and duties and all kinds of things, probably, too.
Well, I was going to say I'll go with the
Because they rather you buy wine, not Coke.
Yeah.
And we don't used to drink that wine all the time. Correspondent banks. Oh my goodness, all at once you have to deal with banks because you don't send cash, you don't send your check, you go to your bank, the bank there, and you have I mean, it's so much involvement, especially when you had banking. You remember some of this bank accounts. It's not that you deal directly with one bank. 2, 3 bank deals with that so many times. Oh, I love this thing. Letters of credit. You have to have a letter of credit because you have more than one agreement. Not only you have an agreement as a seller to the buyer in China, for example. You have now an agreement with the bank as a seller with your bank. The bank has an agreement with the buyer bank. And then the buyer bank has an agreement with the buyer. You have all this agreement to deal with it. You really have to be, and you think you have the time to read all this stuff? No, you don't. You know, because most of us do not go around with a lawyer walking with all the time and give it. And then also, if we did give things to the lawyer, they tells you to wait another week. And in the meantime, you lose the sale. So many times we do transactions that I'm surprised at because we're working amicable, thank God. When you want to get out of the country, that's when you find problem. Conditional promise by issuer the bank to pay the beneficiary the seller on behalf and account of the buyer. This is about 4 agreements going on at the same time. This is something you have in your book. Give you the design. Then you have to have the bill of lading. I mean, this paperwork You need somebody just to take care of this paperwork. International is very interesting. It's very interesting to do that kind of stuff. And of course, there's a chronological events. In your book has a nice thing. So when you take the multiple choice, open book, you know, look up on this thing. It's pretty good because this is more terms, and the multiple choice is more terms. You know, what do you need to do this? You know, you might have a list of things, and then you have a letter credit, something to do with international transaction in different country, and you see the word letter credit, and you see other things that it's impossible, like prospectus. You know, prospectus, nothing to do with international transactions. So these are some of the terms that you have to fit with what we covered, and it's just terms. So, almost done. United States laws in a global context now. Do United States laws apply to other nation business? That's what Jenna was asking before. No, especially when what? Most of the business is owned by what? Government. And they have their own laws. You know, if you want to pick on criminal law right away, you're guilty and you have to prove innocent. We have it reversed. If you can't remember something, we have a tendency in the United States to do things reverse of the other nation because we don't want to be like other nations. And I find it so interesting because now that we have so many immigrants come over here, I mean, this is a nation of immigrants, we immigrants wants to be what? Like the other nations. We want to have things like the old country. Make up your mind. You know, if you want to be, have things like the old country, especially my parents used to drive me crazy. You know, if you want it, then why did you come here? This is a new nation, a new language, new culture, new way of doing things. Oh, but they should have this, and they should have that, and they should do this, and they should have the parsley, and they should have the Chinese food. Yeah. You left that, you know, have the good old hamburger. That's too bad, you know. But I mean, but you see what I'm saying? Because we live in that, and we are a land of immigrants. And now we try because under the Constitution, we have to treat everybody equal. So if you like Chinese food, then we have to have Chinese food. If you're a vegetarian, then we have to. It's under the Constitution, you know. But the whole point is then, why did you leave the nation to start with? If you like that food. Because when you're in China, you don't know that you're not going to have Chinese food over here. you think that everybody has Chinese food because my nation is, I remember, I thought everybody's going to have spaghetti meatballs when they come over here. Instead, they don't, you know. And it's just there. We just don't think of things like that. But when you're doing business, you have to be aware of that. When you're going to go over there, they're not going to make hamburgers, especially for you. You're going to eat their food. They come over here, we try to do that. Because of the Constitution, not because we want to. Because of the Constitution, because we're supposed to do that. We have United antitrust laws, competition, not a monopoly. Competition, we're going to have the court split up the companies. Apply if foreign conspiracy substantially affects. So any company that becomes too powerful or from another nation that does business with us and they are a monopoly in their nation, especially if they're owned by the government, we're going to interfere because it's affecting commerce. Because we in the United States wants to have what? Equal opportunity to have commerce with differences of way of doing things, not just one way. You know, it's very important with that. And we lose a lot of money sometimes because of that. We really do. But, you know, international tort claim often involve human rights allegations. So, like I shared before, immunity then, that's okay if they mistreated their people. But if we are in agreement with a government company, we're going to be liable, but not the government company. So you have to be careful of those things. Anti-discrimination laws. Generally, the United States firms must abide by the United States anti-discrimination laws, even in the foreign activities, unless doing so would require them to violate the laws of the foreign country. What does it tell you here? United States, you can follow. However, if they are not like what? The other nation, then you cannot follow your own laws. So in a way, they should say what? United States, you have to follow what? The laws of the other nation. I would have it the other way. You have to comply with the laws of the other nation unless their laws is similar to ours. Then you can comply to ours. You know, to me it sounds silly the way they have it over here. They make it sound like, you know, yes, we can use their own law unless they don't like our laws. It's the other way around. They usually don't like our laws, and so if we can find someone that likes our laws, then that's great that we can use our laws. You just, the comity, remember? I mean, it's overwhelming. Food, time, different way of doing things, they just do it. McDonald's had to change Oreo cookie. The other day I heard, you know, in China, Oreo cookie, they are not the same like we have here because nobody liked it when first they changed the whole thing. They have different shape, they have different flavor inside, you know, because otherwise they don't. And then, and I remember, I don't know, maybe you had the experience. Breakfast. Do you want American breakfast or you want, yeah, they have the different kind of, yeah, right. Now here, you have breakfast. You got this big buffet thing of fried bacon. They don't give you a choice. Do you want a continental or do you want this? Everything is there, and you pick whatever you want. But I remember they would say to me, do you want to have an American room, or do you want to have one, you know? And I did not know if there was such a thing as an American room. What they expect? What is it right away that I thought? American room probably is going to have what? Toilet paper? Shower? I mean, give me a break. And they asked me this question, do you want an American room or you want a one, you know, standard one? And I'm thinking, oh, I hope they have a toilet in the standard one, you know what I'm saying? Because the American room is going to cost you more money. And then you start wondering, maybe I should check first to stay in the room and see what happens then. Then I can always switch to the American room. We don't have this kind of thing, you know. We might have it, you know, the higher floor or different floor. You want the king-size bed or the single thing or single room or whatever. Completely different way. Okay. Civil Rights Act 1991 applies Title VII extraterritorially to United States employees. Oh, I have the case. I have to give you this one. You know about this one? Okay, here we go. First case. This goes under the Burmese Act. Maybe I mentioned this to you. Stop me if I did. Boston Scientific Corporation is headquarters in Massachusetts, but operates globally and has subsidiary include Boston Scientific Argentina in Argentina and Boston Scientific in Brazil. So they have two of them. While working for Boston Scientific Argentina in Buenos Aires, Ruben Carnero, a citizen of Argentina, accepted a simultaneous assignment with, Boston Scientific Brazil. Okay, when he reported to the one in Boston that his Latin America were engaging in accounting misconduct, so that's protected under what? Burmese Act SACS. His employment with Argentina and Brazil was terminated. He's reporting to Boston that something's going on in these two places, you know, and next thing you know, he's terminated by Brazil and Argentina. So what do you think he's going to do here? He's going to file a complaint. First he went to the Department of Labor because it was an international thing against Boston Scientific in the United States under the SACS seeking reinstatement because he was saying what? Here I'm whistling, I'm supposed to be protected, and that's why I gave you last week the key terms. In your book you have it too, but I didn't see it the last chapter. The Department of the Labor rejected the claim. This is no, we have nothing to do here. Why do you think they didn't want to have anything to do with it? It was a citizen of another. We're not going to interfere what people, you know, terminate you in another country, and they want to terminate their employees. It's none of our business. Nothing to do with us. So next thing you know, he goes and files to the district court against, he comes here in the United States in the regular court. The court dismissed the complaint and Carnero appealed. So he's losing at the lower court, he's going to the appellate court. Issue that SACS applies to acts that occur outside the United States. In this case, no. The United States Court of Appeals affirmed the lower court dismissal or complaint. Why? Does not reflect a necessary clear expression. Again, these courts are saying, hey, there is nothing on SACSA that says that it covers also non-citizen. SACSA at the present only covers citizens. The whistleblower is supposed to be there to protect investors, not American citizens. Very interesting, because I know then that about 2010 there was a case in New York that says the same thing. This is, wait a minute, this is something to do with investors. It doesn't have to do with American citizens. That's what I call an active court. This one was a passive court. They figure, you know what, we're not going to get involved in international problem, because who knows if Argentina is going to like we telling them. But it was an American company, and it was about investment of an American company. But the act just came out. It was interesting because of that. Cornero had been a United States citizen working for the company in the United States and had been fired for reporting the same account, and then he would have been protected. So it's another thing you have to be careful. And of course, by doing that, what are they encouraged to do? By doing that. But it's okay, you know, even if you are working for a subsidiary company, American company, and the employees are not American citizens, and they see problem with accounting, and they say, no, there's no protection of whistleblower. What kind of behavior does encouraging American company do? Do we want then to have people working here, or do we rather have people working where? Over there. Because we can do all the corruption we want, and that's okay. Because if you open your mouth and you say anything, you're going to be terminated. So this is why sometimes when you hear the candidate, you know, they want to do this, they want to do that, they want to bring that. All these laws we have, and all these cases, and it's very confusing because you have to do a lot of changes. And I don't know if we can do all the changes that they think we're going to be able to do. The court held that the explanation was a pretext. The employer segregates and classifies managerial work. Oh, this is a good one. This is something to do with Japan. Case involving charges of discrimination on the basis of national origin. Japanese company employer claimed that he's firing of certain employees as a result of the employer poor financial situation and a necessity that employees speak a certain language. Okay, so it's a Japanese company, Fortino. The court held that this explanation was a pretext. The employer segregated, definitely was discrimination, and it was just great because they won at the lower court. As for the language requirement, the court noted that in the past, many Americans origin employees who did not speak Japanese had performed the duties, and the employer contended and everything was happy. So this is the lower court. The United States Court of Appeals reversed the $2,500,000 under Title VII national origin discrimination judgment in favor of 3 former managers of a subsidiary of the electric company of Japan. Now, why? In reduction in force, the company had terminated 66 out of 89 managers working in the United States, while none of the 10 Japanese executives were terminated. Under the Treaty of Friendship, we have a Treaty of Friendship. We want Japan and the United States to be friends, to play together in the same box. Commerce and navigation between the United States. You know, this is the treaty in Japan. The companies of either the United States or Japan are free to engage within the territories of the other party executive personnel of their choices. What they're saying, we, an American company, goes to Japan, we can what? Keep all American people as long as they have what? Executive position. And Japanese company can come over here and they can hire only Japanese people as long as they have what? Executive position. What's an executive position? Manager, salary. You don't get paid by the hour. You have a salary. Managers is executive position. Anything, directors in executive position. Anything that you get paid on a salary, it's executive position. So this is why we have a lot of disagreement in United Nations. It's very interesting between nations that we cannot do certain things, even if it did look like they were what? Terminating on the national region all the American people speaking, and their excuse or their reasoning, I should say excuse, is because they don't speak Japanese, you know. And we have some time in this country, we have American companies that does the same thing, you know, that they don't speak the languages and they terminate them, and then we do have a cause of action. And the court has a problem there, because if you're dealing with customers and clients like in a bank, and you have a strong accent, even if you're very good, the bank can terminate you. Because what happens when someone speaks a language and they have a strong accent? What kind of environment does it make it? You cannot understand, right? What kind of, how do you feel that you don't speak their language and they speak in their language? They feel what? Yeah. We have the word hostile environment. Yes, so PNC Bank was the first one that started this whole thing. So you're going to start seeing more and more. So it was very interesting because of that. Because they're saying, you know, you speaking another language, having the accent, it's not so much. If you're dealing now, if you can be in technology and you're all by yourself, that's fine. Even if you don't know, you know, because you're working with computer. But if you're going to start dealing with people like a manager, project manager, dealing with other people, and you have a strong accent, you may have a hostile environment because you feel uncomfortable because you don't understand the person. You don't want to ask the person to repeat it again. You think that's what the person said, and you feel uncomfortable. You know, and then the bank in this situation was saying that people don't come to certain teller, they just come then, you know. And, you know, I can see the problem there, but the bank says, you know, it's okay. You can make the rule, you know, no speaking, only English rule, they call it, English rule speaking. You're going to start seeing more and more companies doing that if they don't want to be bothered, because they don't want to be sued under national origin. So it's interesting because of that. Only if you're dealing with people, you know, with other people, because you're making, the term is a hostile environment. And we do. We feel uncomfortable when we're here. I think we're more used to in the United States, especially in Newark. NJK, I don't know about Rutgers here, but NJIT, it's very seldom that you hear people speaking English. You hear all kinds of languages, but very seldom that you hear people speaking, and the students speak their own language. We have a lot of languages over there. And it's, you know, it's acceptable behavior. I mean, they're international student. That's what there is to it, you know.
Is that legal for a private company as well?
Private company, yeah. Why? Because of hostile environment.
To prevent an employee from speaking their native tongue? Like if they're
Not if they're going to make a hostile environment. Because who's responsible if there's a hostile environment? The employer. Yeah. It's something that started the hostile environment because of sexual harassment. That's the way it started. This is where sometime, you know, now we have cases that parents sue McDonald's and Burger King because their kids are fat, you know, and the court says, stop it. This has to stop, you know, because I know what happens then, you know. But of course the cases did help, and now you have salad bars and stuff like that because, you know, they don't want the kids to be fat. But I know that that's going to change because that used to happen with cigarettes, and I know in about 25, 30 years we're going to be all concerned because all these kids that were fat when they were younger, now they're having heart problem, and this is all Medicare and health insurance. Next thing you know, all this company that you made all this profit selling all the potatoes and fries and that kind of thing, now you have to pay back society for all the profit you make because you were the cause of their heart pressure and everything like that. So I can see that's going to happen. But the thing is that I want you to see, when it comes to international business, we have treaties. We have agreement how to treat our conduct, behavior. You see that? Executive people makes decision. Therefore, it's okay, you know, to have executive people that speaks Japanese because you understand each other better. Many times even the language has a different meaning when you translate because there's a lot of culture in the same, in a word. And you might say that and you translate and does not have the same meaning. And then you have misunderstanding, then you have no mutual assent. Remember the bubbles I always call it? There is no really contract if there was not clear. Well, I thought you say this. And then many times when people translate something for you, how do you know they translate what you want them to say? They're going to translate what? What they think you said. You know, and this is why in court, whenever you want to be a translator, you have to be certified. You have to make sure that, you know the language and not, a dialect or something like that. And even that, I don't know. But at least you have the certification. Any other questions? I think I'm finished with this. Yes. Go ahead.
I was just wondering, I worked at a Japanese company before. It's headquartered in Japan, but it was like their U.S. subsidiary.
Yeah, okay.
And it was pretty much like there were hundreds of people there. Pretty much all except for like 5 people were in Japanese, and they had this policy that you cannot speak Japanese in the company at all. And I mean, people did anyway. But like, is that because they didn't want to create the hostile environment?
Yeah. Especially, I have to tell you, we, like an NJT, there's one professor that speaks Italian like I do, and there's a director that is African American, and we were speaking in the hall because this morning we were saying hi, this and I'm assuming, presuming, she come out of the office. She says, I don't understand a word you're saying. I feel like saying, well, you're not supposed to hip drops either. That's illegal. But I kept my mouth shut, and she says, you're making a hostile environment, and it's only 9 o'clock in the morning. Don't worry, she has a flat tire in her car. Okay, so. But I mean, and she probably felt uncomfortable. I don't know. But what? I think I know why. First of all, what do you think when people speak another language? Yeah, she probably, being Afro-American, we both white, we speaking Italian, maybe we say something about black people. Who knows what she thought? Who knows? We're speaking with our hands and this and that, she's trying to figure out body language, and who knows? And I guess that was hostile for her because all at once she couldn't concentrate on the emails or whatever it is because she was trying to figure out what we are saying, and that's hostile environment. You cannot do your work. So I guess that's what it means. Not so much. But I thought that was interesting, because I wanted to say, well, you're not supposed to really listen to what we're saying. You're supposed to work what you're doing, But I kept my mouth shut because already people don't like me because I'm a lawyer. Okay, any other questions you have on this? Do you understand the logic? Because you have a couple of questions on that. Not as much as on banking, not as much as on the other stuff that you're going to have on CPA. CPA, I put me much attention on that because I want you to do well the first time. Do you have chances to take the CPA exam over and over again? And if you don't pass, what can you do as an accountant? You still can work?
Yeah,
Oh, okay. Well, we cannot go to court. Okay. Any questions about do you understand the logic here? The agreement, it goes back to the contracting again. That mutual assent, understanding. When you speak different language and different currency, there's a lot of problem. Especially if there's an accent then, you don't even clearly to understand that. Sometimes even writing, you have to, don't hesitate to ask the question. That's another thing. We are afraid to ask questions. International students do not like to ask questions. Ask questions when you're not sure something. American students too don't ask. There's only certain people that feel more confident to ask questions. There is no silly questions because it's important for you to understand things. That's why I don't like multiple choice because you really cannot ask questions. But I'm hoping as a group that you will talk to each other to make sure that's what the question means. Because then you get the hang of it, the kinds of questions to do it. Any other questions? Do you want to take a few minutes break? And then we just go over the outline, and then I'll give you you can't wait to see your exam, right? I can see it, I can feel it. You can't wait to see it. All right, you want to take a break? About 5 minutes? Now, should I count all the people now? I will try to upload the final on Blackboard tomorrow when I go to the law office. I'm going to try to do it as soon as I get in before I get involved with their problem, because otherwise I forget. It takes me time to get to the Blackboard. Yes?
I think I don't feel well.
You probably stressed.
I am, I know, I'm like,
Do you want to? Yeah. Today. Which country? Yes, you do. You know, guys don't never look nice. Very seldom. Okay, let me go over this first because I see it's already almost 3:30 and I try not to. This is something to do when you, as a profession, are liable. You're going to become liable. There is such a thing as ethics. You know, remember consequences. You're going to reason why you did certain things. Consequences for the good of society. Here is something that, watch out, accountant, because you may be liable if you don't behave as what people expect you to behave. And one of the first things we have common law, case law, and then we have statute, because the statute says you're liable. And this is a little bit more difficult because no matter what you say, the statute makes you liable, period. So this is a little bit more dangerous. Chapter 22, common law, breach of contract. Breach of contract. You promise me you're going to do this. You promise me you're going to do that. Be careful when you promise your client something. Promise. Like, you know, sometimes I'm making a joke. I promise you we're going to leave earlier. We're not going to take break. And then next thing you know how many times I was late. That's really breach of promise. So I really should not use the word. Don't try not to have that word, I promise, because people take it literally. Most of the time, you know, and the other word, be very careful when someone says that to you. I rely on your word. When someone says, I rely on your word, remember, because next thing you know, they're going to take action on your word. And of course, if they lose, whose fault is it? Yours, because they rely on your word. But that means you can use it too. When you go to buy something or you go someplace, you rely on I rely. As soon as I hear a client say, I rely on your word, Diana, that the judge's going to rule in our favor, I have to say, no, that's not what I said. You know what I'm saying? Right away, because as soon as I hear the word, and I use it a lot, I'm relying on your word that you promise that this is going to do this and that. You know, and if they don't pay attention to my word, they're in trouble. If they do pay attention to that word rely, usually they go and get the manager because they want to make sure. So when you have a breach of contract, it's a promise. So when you say something and the person takes action on what you said, you encourage him to invest it, you think it's a good deal, don't do that. You know, don't do that. Because for them, they might be relying on your wording, and that's breach of contract. Just words. In the United States, words, when you say words and the person rely on your word, it's a contract, even if it's nothing in writing. But the person that rely on your word have to suffer damages. If they make a lot of money, they think you're great. If they lose money, they take you to court. So this is the way it is because we don't like to lose. Negligence. They suffer damages again. So you can be sued for breach of contract. You can be sued what? Because of your contract or relationship with the client, you have a legal duty to not harm them because you know better. Because of your position. You're not supposed to encourage them to do something that they might get hurt. Or otherwise tell them. You know, just like I said, as long as you give them a choice. It might be poor choice. You might be raped or killed, but you give them a choice. If you go this way, you're going to lose $10,000. If you go this way, you're going to lose $20,000. You choose how much money you want to lose. And of course, if you go this way, you might also win $10,000. Those are the things. Choices is so important, even if they are poor choices. Fraud, which is really misrepresentation. Now, fraud is a little bit more hard because you have to have the intent that you as an accountant, profession, me as an attorney, you intended to hurt the person, misrepresent the person. You know, maybe misrepresenting, like some people might be misrepresenting they're an accounting and they're not an accounting, or lawyers or doctors, you know, or misrepresented there are certain situations going to happen. And fraud is more with intent, but most of the time we use the word misrepresentation. And third-party liability, this is something new. Something new, the third-party liability. That means you're gonna be liable, you may be liable because of the contractual relationship, because that's what it is, a contractual relationship. But because of that contractual relationship, a third party may get hurt. a third party may get hurt. And that third party then may sue you. But then it's a little bit more difficult because that party, the third party that is hurt now and is blaming you that they lost money, because usually I'm thinking of accounting and doing something and income taxes and stuff like that. Next thing you know, the third party say, well, I did that what I did because, you know, he told that to my brother or my sister. I'm a third party and it's because of this. So even if the person that you deal with it did not take action, but the third party took action to do something, you have to be careful. You know, this is where many times we have affidavit, we have to sign it. One of the first things when somebody comes in your office, like they come in my office, we right away say this is confidential, attorney general privilege, because sometimes they bring their spouse, sometimes they bring a neighbor, sometimes somebody's giving them a ride, and they come in my office and they start telling me their problem, and I'm thinking, oh my gosh, you know. But you're not dealing so much with problem as much as with money. So you have to be careful. You have to have something that this is, hey, does the third person knows that what happens between you and I, it's what? Just a privilege between two and you have not, it's almost confidentiality. Confidentiality. And if you can, put some of the document confidentiality, because then if they reveal that information from those documents, you have breach of contract. So these are the things that I'm trying to, this is so important. Of course, statutory liability, that's because Congress wrote this legislation, and this is all federal. You're dealing with federal. We don't have yet any state of security. We have state law because of branch law. This is state case law with state laws. We have this now. So because of this, you might use that as a state because this might not protect you. But this is where you have the federal government, and we just cover stocks. You know, you are investing money, you're giving advice to invest money, and next thing you know, you see that something is going on with the company you're dealing with, because you're going to spend, and you can see the key points. It's very important. This one here also, they have a board now from the federal government that come over and auditing things, and that's taxpayer money again. And of course, we covered the Security Act of 1933, not 31. We don't have that. Okay, and next thing you know, Section 11 and Section 12, and because you have to prepare so many documents, you have to disclose so many information, and of course, if you make a mistake, if you do all kinds of things, you're going to be liable under this statute. If it's an individual person, you might be liable then state negligence. This one is when you prepare paper for the government, for the regulatory agency. This is not involving individual people. You're representing a company, you're preparing the form, you prepare this, and this is where you're going to get in trouble. Where over here is more individuals. Maybe even a company might take you, you know, if they have a contract with you as a consultant to do things. But that's what the difference over here. And then, of course, you have the Security Exchange Act of 1934. These are the three areas that I know that you may be liable, because the statute says that you will be liable. And if you read it and you have it in your book, you're going to see it. It's all about paper, filling out paper, register with the agency about certain, it's just amazing. Those are the area that you will. And then, of course, case law, which is common law, is when an individual sue you. And there are cases where Martha Stewart, for example, she was a criminal under the Security Act because of what she's doing inside of trading. Because you're going to have information that you can invest money, but you know, not everybody has the opportunity. And also the Security Exchange Commissioner sue her here, negligent. You know, those are very interesting because you don't hear about the civil case, but you heard a lot about the criminal case, because the other case, the original case really was the other guy that was criminally. Martha Stewart was just a tool that she was involved in that case, but it wasn't really her case where she was security exchanging versus Martha Stewart. It was the other guy, and Martha Stewart has something to do with it. So these are the things that I'd like you to know. Anything else? Because that's all you really need to know. The book has different cases, but that's what they use, a different kind. Any questions? Most of it is that contractor relationship, one way or the other, or because of you having a legal duty, or because you have a relationship again, and because you have you know it, you're the expert. And if you're dealing with equal bargaining, then it's a whole different thing. And over here this is why, for the good of society. We want to make sure we don't have an arrow in a gun. We want to make sure that you playing with numbers, you're not taking advantage of taxpayer. You know, they don't care that you were forced to cheat on the numbers. They don't care that the employer, they don't care that. And then it says if you do care, then under SACSO you should whistle, but you lose the job because no whistleblower ever is going to kept working in the company. You know, and if media get hold of that news, no other company is going to hire you because they say, oh, is that the whistleblower? Forget it. We don't want him here. You know, so those are the things that it's your decision what you want to do about it. And remember, I shared with you, you want to think of consequences, you might not whistle because you don't want to lose the job. If you think for the good of society, because look all the money they're taking from taxpayer or that they should be paying taxes for it, then I should say something. Now the IRS also have the whistleblower statute, you know, where an accountant call up the government. And remember, when it's a false claim act under the whistleblower, is it the IRS? If it's millions of dollars, you're going to get 25% of the judgment. Because anything to do with government is taxpayer money. And for the good of society, for the good of the taxpayer, it's nice that they get all the money back. Consequences, you probably lose a job. So you have to decide what to do. But then if you get 25%, I don't know, maybe it's not a bad idea to lose the job. You know? So those are your decisions. Any questions about this? Because it's pretty white and black, I think. No questions? You understand the logic? You see what happens? Good. Okay, let's go over some of the cases and then we'll dismiss. Maybe at least one or two. And this is a little easier. It's nothing to do with numbers. It's something to do with comity, about nations. It's something to do with dumping, anti-dumping. I tried to pick something that you might deal with it if you are in a global economy. Who would like to read problem 1? Who has it? Howard doesn't even want to look at me anymore because he's afraid that I'm going to ask him to read it. You want to? Thank you. Poor Howard. Pick on him because see what happens when you sit in the front? Okay.
Consulting Limited is a U.S. corporation that sells lumber products in New Jersey, New York, and Pennsylvania. Domain Industries Limited is a Canadian corporation that also sells lumber products, including green hemp fir, a durable product used for home building. Domain supplies more than 95% of the green hemp fir for sale in the northeastern United States. In 1990, Domain contracted to sell green hemp fir through E&L, which received monthly payments plus commissions. In 1998, Sherwood Lumber Corporation, a New York firm and an E&L competitor, approached E&L about a merger. The negotiations were unsuccessful. According to E&L, Sherwood and Dorman then conspired to monopolize the green hemp fir market in the United States. When Dorman terminated his contract with E&L, the latter filed a suit in a federal district court against Dorman, alleging violations of U.S. antitrust law. Doman filed for bankruptcy in a Canadian court and asked the U.S. court to dismiss E&L suit under the principle of comity, among other things. What is the principle of comity? On what basis would it apply in this case? What would be the likely result?
Okay. So you see here, there's emerging, there's antitrust, there's a lot of situation, but they go into court, why? Because of comity. It doesn't discuss any other illegal things that maybe may occur in the situation. They start, let's first figure out, do they have any authority to even take us to court because we are not the nation? So there is, you know, those are the things that I want you to see right away. What's the issue here? And of course, in this one, I'm giving you the issue. But many times, you're going to have these things involved. So what do you think? Is there something, this is Canada. Does Canada have similar laws like we have? Do they have common law? Or do they have civil code, for example? Do they have something like antitrust? Are we similar some way, somehow, in our formalizing behavior more than like India or Japan? You know what I'm saying? Yeah, so this is something that right away you can say, well, maybe it is comity. Maybe it's okay. Maybe it's one of those things where we're not going to interfere with what's going on in Canada because of comity. So those are the things that, what about the antitrust law, and what about anything else? What does it feel? Do you have, what does it feel inside of you? Because these are the things that I want you to start to figure out right away. Is there comity? And that's what, first of all, you have to define it. What is comity? Committee. I pronounce it committee, but I think it's committee. What do you define it? What is it? It's when you what? Give respect to another country law. You're not interfering with their laws. I'm not talking of judicial. I'm not interfering. This is not act of state doctrine. I'm not going to interfere. As long as their law is similar to ours, then we're not going to interfere, because we know justice will prevail just as much it would prevail over here. So there is no reason for us to ignore them. So those are the first thing you have to do, and then you apply. So in this here is the court. The comity is the words in the court, the recognition which one nation allows within its territory to legislative, executive, and judicial or act, all three branches of government of another nation, having due respect for that situation. So then defining constantly, and with respect to bankruptcy proceeding, American courts also are very consistent, recognize the interest of the foreign court. They have bankruptcy laws like we have. They have antitrust very similar to ours. Therefore, we're not going to interfere. We're not going to interfere in the way the Canadian company is running their business. We're going to respect the way they're doing there. The court ultimately resolved this case, however, on other ground. And this is so interesting to me, because even if we say, okay, and this is what we call it, an active court. Yeah, under that, we're not going to interfere. However, there is some injustice going on here. And that, from reading the fact, you see that something's not. So here the court, the United States, are saying, however, we're going to do something else. We're going to act on something else that we don't think it should be continued behavior to be done. And what they did in this situation is the holding that the plaintiff antitrust allegation are insufficient to state a claim as a matter of law. So first of all, there's really not there's not enough evidence to take this case under antitrust. Very interesting because of that. I always find that. They always find something that, wait a minute, we're just going to dismiss something here because there is not sufficient evidence that this should be heard or tried as an antitrust violation. There's not sufficient evidence. That's what we call it, active court. They didn't even remand it. They didn't even do anything. But this committee, yes, we're not going to interfere. We're not going to interfere. And it could be because they didn't want to interfere because there was not enough evidence. That's another thing that I thought about it. We're not going to even waste our time because there's not enough evidence that there even is an antitrust. So if they did anything like that, we're going to leave the Canada to deal with it. Does it make a little bit of sense here? Does not mean that I agree, but that's what the court said. Problem 2. We would like to read problem 2. That's another long one. Thank you. The people in the back. Go ahead.
A newspaper printing press system is more than 100 feet long, stands for 5 stories tall, and weighs 8 million pounds. Only about 10 of the systems is sold each year in the United States. Because of the size and cost, a newspaper may update its system rather than replace it by buying addition. By the 1990s, Ghost International Corporation was the only domestic maker of the equipment in the United States and represented Philippines, TKSC, FC, and others alleging illegal dumping. At what point does a foreign firm's attempt to compete with a domestic manufacturer in the United States become illegal dumping? Was that point reached in this case discussed?
Okay, remember, this whole thing is always what? Preponderance of evidence, not behind a reasonable doubt. So what they're courting asking, when is it just running the business and when is it dumping? Because dumping is against international law. But if it's just a method of running the business, then we're not going to interfere. So what do you think? It is, yeah, it just sounds like because of the price, because also what they found, all kinds of email. Well, it doesn't say email. It says what? Letters, correspondence. That means they were going through already interrogatories. They didn't go to trial yet. But you mean that already they had filed the complaint, and that's so they tell you some of the evidence that already they went through it. So this is why this is helping you already. But remember, this stuff does not come until you file the complaint. And of course, they file the complaint, and then they're finding out this. Then you get some of the facts that already we know from going through the case. And of course, they always settle out of court, but they wait for the court. In this case, they went to court. And the jury found that TKSC unlawfully dumped its product into the United States market and awarded more than $10.5 million in damages to Gus. TKSC appealed, but the appellate court affirmed the award, which is interesting because usually they reverse. The appellate court explained that unlawful dumping can occur, this is the point, when a foreign corporation intending to injure or destroy a certain market in the United States. So it's not the way, you don't intend to do it. But they had enough evidence to show that they want to take the whole market, become a monopoly. And that definitely is dumping. The third one is very interesting because it's something, again, international law. Who would like to lead the third one? Third? Oh, thank you. Somebody in the back. So here we're going to find out, is it the immunity? Is it the government? Should we, they do no wrong? Is it something that they are responsible? Is it a commercial activity? All those things that comes in question over here. That should then the United States even hear the case, and then which way they're going to go. So what do you think? This government is Republic of the Philippines. Then they're going to say what? We are immune under the foreign, but the thing is, we, the United States, are going to say, well, let's wait and see here. Let's wait and see because there is such a thing as commercial activities. What do you think happened here? Is there? Should the Republic of the Philippines get away with it? Probably. Is there any sovereign immunity, or is it a commercial? Because that's really the problem here, because otherwise we cannot tell them what to do or interfere there. So let's say the key international legal principle at play here is our comity and sovereignty immunity. Because again, that's the general rule. Okay, now we're going to have the comity requires one nation to give effect to the laws and judicial decrees. And of course, they had problem already in the Philippines whether the property should be taken away or not to pay the debts that he owes to the other court. So when it prevents the United States court from exercising jurisdiction of a foreign nation unless certain conditions are met. In this case, United States Supreme Court reversed and remanded the Ninth Circuit decision. The court found the lower courts gave insufficient weight to the sovereign status of the Republic of the Philippines at its commission in considering whether the interest of those parties would be prejudiced in the case proceeded. Giving full effect to the sovereign immunity promotes the comity and dignity, and you know that. Okay, the claims here arise from an historical and political significant events for the Republic and its people. They have a unique interest in resolving matters related to a realm of assets because they are personally getting injured, the people. A foreign state has a community interest in using its court for a dispute if it has a right to do so. Other nations should not bypass the court of the Philippines without good cause. To seize assets of the Philippines would be a specific affront. The lower court erred in ruling on the merits of the case. The Pimentel class has interest, but the courts did not accord a proper weight to the compelling sovereignty immunity claims. So here the court, what we are saying here, we're not going to interfere. We're not going to interfere. First of all, because what? Comity, we have to accept their laws. Second of all here, the lower court did not put so much interest. Hey, this is the government dealing, and the people are hurt, yes, but hey, the government has sovereign immunity, and we cannot tell how to run the business to a government. So they remanded the case for more proceeding. Usually, they don't go over the case again. They usually settle out of court because you don't want to start all over again. In criminal law, it's the only time we start all over again, but not in civil actions. We never do that. This is a little bit more detailed, but I want you to, the thing really that I want you to do is be alert. Be careful. Be careful when you're dealing with international business, or you're selling, or you do accounting, or you're working for an international company. Just be careful because international law can kick in, and it's different from the one. First of all, international law is natural law. Do you remember that on the first semester? It's not positivism. International law is natural law. You should know better. So it doesn't matter what your employer or your company says. You have to do something about it because otherwise you're going to be liable. So it's interesting because of that. Any other question? I didn't give you any more because I know you want to go home. It's Thursday and you look tired. And I'm hoping that I have internet connection because that's in my mind. And I have the I printed because I couldn't upload it on Blackboard. That's why I have a box. Everybody says to me, is that their final exam? I said, yes. Oh my God. I says, yeah. Oh, I thought you were a nice teacher. I says, well, that's your problem. Yeah, I never said I was nice, you know. Oh, are they going to do that? I says, yes, in 1 hour. Oh, my God, you know. I scared them. I don't think they want me to teach anymore there. No. I tried, it's pretty much everything from the midterms to today, but I have some question on agency law because you didn't do too well in agency law on the midterms. Most of you did not understand it. So I figure out just because they're going to have it on CPA, I don't want you to sue me for intentional emotional distress that I cause you. Okay? 200. On the exam, 100. Yes. Yeah. No, this one I cover more because I'm thinking of the CPA. If I didn't know about the CPA, I wouldn't do that. Yeah. Yes, cover more. Yes. Yes. I want you 100 of that. The same question, but only 100 out of it. So you might get 1 or 2. You know, I'm trying to mix it. But you get time. Okay, you get time. We have next week class to take the exam. You're going to have it here. Oh, I know. There's some students already. You have to let me know. Yeah, but I'm not here. So what happens is I have to tell Professor Sanella and I have to give him the final exam, and then you take it up in his office. Oh, yeah. You're still